Web result.
Yes.
I have to mention for listing matter. Criminal appeal matter is pending last 6 years. 2018 matter.
The court master, let them make some adjustments.
Yes, but
Web resolution. Recommendation for listing an ID criminal in criminal appeal. 20 years of jail. We are under inside the jail for the last 1 year, 3 months.
Only.
Your lordship, if the matter is heard, then
No, not that. Give to the court master, they'll have to make some adjustments.
much of it.
Mr. Mandan, we are uploading your orders today. Yesterday we could complete it. Item 1.
Matter your lordship, last occasion, your lordship directly have to get the report of service of police.
Okay.
Yes, lordship, we have already sent our written intimation, lordship, and the report is coming, it's just on the way, I have just verified now, lordship,
Okay.
to some time.
After some time.
Yes.
You tell me he must be busy. Tell the time. We'll take it up at 2 o'clock then.
Okay.
You come comfortably
Lordship,
at 2 o'clock.
God bless.
Item 2.
Here also, your lordship has direct. The copy, no? The copy.
Yes, Mr. Fugan.
That it has to take instruction where the notice is served upon respondent. But if that notice is only duly served,
It's served
that is already.
on record. Okay. We will appoint an amicus then.
Lordship.
Uh, Ms. Burman, can we appoint you as an amicus in the matter for the uh, for the victim, POXO matter?
Respond in number two.
Legal aid also.
Hmm?
And legal aid also. Right.
Yes, his name is there.
Or Mr. R. Fukan, legal aid counsel for the appellant. Ms. S.S. Boral and APP has referred to the office note dated 5/12/2023, which indicates the notice has been served on respond number 2 through the officer in charge of the jurisdictional police station. So as the next para, as none appears on call for the respond number 2, comma. And having noted that the appellant has been convicted for commission of offense punishable under section 6 of the POXO Act, comma. We are inclined to appoint Ms. M. Burman and legal aid counsel to represent respond number 2. This paper records have come? No,
Paperwork is also not ready.
no, if the LCR is not from paperwork will not be ready.
Yes.
Um, It appears that LCR, it appears that LCR is not received. So according to the registry shall requisition the LCR. Of special within bracket POXO, bracket close, case number 3 of 2021 from the Court of Learned Special Judge within bracket POXO, Sivsagar. List of 4 weeks awaiting receipt of LCR. Next para, the registry shall reflect the name of Sam Burman and legal aid counsel for respondent 2 while listing the matter next.
Item 3.
Yes.
Letter, I'm seeking bail in this pending appeal under DPS Act. 10 years. 10,000. But the accused is in custody for the last 6 months. From July, he is there. And prior to that also, he was in custody for 4 months. Now, here, Lordship will kindly see, my ground is limited. Firstly, the conviction is based solely on seizure. Of commercial quantity was seized from this publication. It was done after sunset. First was made after sunset. No safeguard was followed. Section 50, which is mandatory, was not followed. Only one witness has said that this was seized in my presence, but he is a son's witness. He is not a witness who was called and told, look, I am going to deal. You are to witness. He says, I suddenly saw some people gathering there, I came there, and this was my signature was there. PW1 and PW5 is the officer, the investigating officer. I hope. If I take your worksheet to the judgment itself, at page 21, Lordship may kindly come through. Paragraph 9. I don't know. My Lordship will kindly take up the appeal,
Yes.
page 21. Paragraph 9, I'm reading it out, madam. PW1 Devasis Day is one of the seizure witnesses, and he deposed that on the date of occurrence, he saw a gathering in front of the pharmacy of the accused. When he went there, he saw that police were collecting capsules on a table of the pharmacy. He had seen those capsules. Thereafter, police took his signature on a paper and packed the said capsules in his presence. In cross-examination, he denied the suggestion that he had deposed falsely. And then PW2, all these are irrelevant here. I am not bothering your watches with those PW2, 3 and all that. Then kindly come to paragraph 15. PW5, Pranab Kumar Deka is the seizing officer, and he deposed that on 27/10/2020 at about 12:30 p.m. The officer in charge of Rudikhata PS received an information that the Sun Medical Store situated near the Rudikhata PS had been selling narcotics to consumers. The information was entered with a GD entry number such and information was given to senior officers. At about 3 p.m., he received authorization from SP Shirang to make search and seizure. Thereafter, he, along with his team, went to Sun Medical Store and in the presence of the witnesses, he conducted the search in the shop of accused, wherein 99 strips of spasmopoximon capsules, each strip containing 24 numbers of capsules, and 8 strips of loose spasmopoximon capsules were recovered and seized in presence of the witnesses. In cross-examination, PW5 denied the suggestion that nothing was recovered from the position of the accused. He also denied the suggestion that he had not followed the procedure.
NDPS Act.
Then 18 Lordship may come to paragraph 18. The Ramsaran Rabha is the investigating officer who deposed that he submitted a state evidence accused for commission of offense under section 33. In cross-examination, he deposed that he has not recorded the statement of so and so, all these will constables who were accompanying. At the time, he denied the suggestion that none of the serial witnesses were present at the time of seizure, and the tablets were not packed and sealed in presence of witnesses. He further denied the suggestion that no contraband was recovered from his office. Now, without going to the other part, my contention is purely on individual protection. Section 50 gives the legal protection to the, not only to the group, but also to ensure that it leaves no doubt about. It leaves no suspicion that the articles were seized after following the procedure laid down under section 50. First, it can be taken out. Section 50.
Yes,
Conditions under which search of persons shall be conducted. When any officer duly authorized under section 42 is about to search any person under the provisions of section 41, section 42, or section 43, he shall, if such person so requires, take such person without unnecessary delay to the nearest gazetted officer of any of the departments mentioned in section 42 or to the nearest magistrate.
this, the procedure would be 50 or it would be 42.
That-
Because it's not a person who was searched, it was the premises, pharmacy.
Well,
Uh,
Pharmacy was searched, he is the owner. Ultimately, the person,
No, he was not searched. This, I did not find anything saying that he was personally searched.
he was personally searched. Lordships want to mean that the premises was searched.
I'm
He
just
was the-
asking you, I don't mean anything, I'm just asking you.
Well,
Is-
a person searched as such the body, and he is searched in possession of the pharmacy.
No, because 42 says power of search, seizure and arrest without warrant. And then if you come to this A, enter into and search any building, conveyance or place.
But Lordship is referring to 42.
42, 1, then you will find A. Enter into and search any building. And then 50 says conditions under which search of persons shall be carried out. Persons can be read as premises, I don't know.
Alert in my submission. Here, the search was made to the pharmacy where he was sitting.
Just Mr. Mahanto, you were just making uh, some check. We found the case diary. In the case diary is, sorry, in the trial court record, the evidence of the seizure list reflects that the time and place of seizure is 27/10/2020 at 5 p.m. at Sun Medical Store, Rumi Khata Bazaar, or something spelling, huh? I may be wrong in spelling. So this is what at 5 p.m. Now that is exhibit P1, seizure list. We'll send you this record. We will send you this record, don't worry. Seizure list is, the entry is 27/10/2020 at 5 p.m. Top. We'll send you the record, don't worry. You can have this. No, it's okay. Mr. Mahathir, don't take the trouble. We are sending you this.
Doctor is referring to this one.
No, this is the seizure list, exhibit 1. This is 27/10 at 5 p.m.
So,
Yes. As per this, what do you call, as per the internet, on 27/10, sunrise was 5:13 and the sunset was 5:13. So therefore, seizure of 5.00 would make it within sunset, before sunset.
well, the 5 has been noted, but the whole process was completed after sunset.
No, maybe,
Maybe.
but that doesn't vitiate. I have not come across a judgment which says the initiation is before that. Merely it has spilled over to after sunset, will not affect. But there is another aspect.
Well,
Uh, as per the internet, civil twilight, there's astronomical twilight, there's a day length, there's a nautical twilight, and there's a civil twilight. Civil twilight on that day, 27th, was 1736. That means substantial amount of sunlight was available till 1736.
that is all right, brother, I am not disputing, but then actually, in particular area, what was the position on that day?
No, if it is in, you see, we go by the, it's okay, your argument is absolutely okay. But you see, if there is a change in what you call latitude by even 1 degree, then it would have a difference of 1 minute. So it doesn't really matter. In Assam, even if there is, we take it from you that there are two.
No, I am not strictly on that,
Okay.
that it was done after sunset. Whatever it may be, he is bound to follow the protection, the procedure as provided under section. Now, Lordship put me the question, whether it is starts on the person or whether it starts on the premise. Well, it is the same, starts on me, because it is me who was noticed, that you possess contraband. I am going to search you. What in your possession? What is, where you have possessed it in my pouch. Therefore, it is the same that I am charged. The allegation is that I am in possession of contraband in my pharmacy. Therefore, in that case, to ensure that it leaves no doubt about that the person.
No, unfortunately, under General Clauses Act, person cannot mean house, because we'll have to accept some source of interpretation. Either it's a General Clauses Act, or we have the Assam General Clauses Act 1934, or we go back to any other legal permissible interpretation of a word. Because if you fail everywhere in this General Clauses Act, then we come back to what you call this interpretation clause, either in the Act itself, or in the IPC, or in the CRPC. Thirdly, if you don't have that, then we go back to law dictionary, Stroud's, or what you call this, Black's. So you'll have to tell us where should we search to,
See, let us first read section 42
yes,
and 50.
yes.
Then let us interpret, or if necessary, we'll go to other. Power of entry, search, seizure, and arrest without warrant or authorization. One branch. Any such officer, being the officer superior in the rank, the peon, boy or constable of the Department of Civil Excise, Narcotics, Customs,
You can omit the first part. A is the only one in this act.
drugs, so and so control.
But it's not your case that he did not have the authorization or power.
He had.
Hmm.
He had the authorization.
So then A only, you can come directly there, enter into and search any building, conveyance, or place.
Ah.
And then arrest. D is arrest. The first is entry in case of resistance, then C is search, and D is detain and search.
So here, what you have seen, chapter 5 is, this act is kept or concealed in any building, conveyance, or enclosed place. May between sunrise and sunset, enter into and search any building, conveyance or place. Then detain and search. And if he thinks proper, arrest any person whom he has reason to believe to have committed any offense punishable under this act. To read this A and D conjointly.
Because you see in the search seizure list, the entry reads like this: 30 strips of so and so, each strip containing 24 numbers of capsules were found, kept concealed in a bag color blue. An airbag containing capsules was found, kept in the bench inside the medical store of so and so, wrapped with newspaper and bound and kept on the bench near the airbag. Remaining 47 strips of so and so were found wrapped with the newspaper and was kept in the bench near the airbag. Out of 47 strips, 39 strips containing 24 numbers of capsule and so and so. So therefore, it is only the because it doesn't say anything about search on the person. He was not touched even. And in the FIR, you will find that they went to this place they reached the place at 3:35 p.m.
So. Well,
No, please.
yes,
We are only doing multitasking.
but I am also trying to introspect into the things and trying to realize what might be in accordance to the language used in the law. And it can you see, Malad? Kindly see, my lord. The whole allegation is that I possess some contraband. In my premises, in my pharmacy, it was found. The allegation is against me. Person, not the pharmacy as such. Allegation is against me. I am possessing. Where? In my pharmacy. In that case, it is required that the investigating authority, seizing authority takes appropriate care that in fact those were seized from that premises in presence of independent witnesses with prior intimation to the witnesses that this is what we have found, our investigation, we are going to do it, you please come and witness it. That is also not done. A son's witness will not do.
Better go through the records because what you are submitting is doesn't match with the record. I'll tell you what has happened.
When evidence it has not come.
I'll tell you because if the evidence is there, only the thing is that I'm correlating. I'm not saying anything which is outside this. You see, this FIR is Exhibit 2. In the form of FIR, the occurrence is of 27/10/2020 at 3:30 p.m. The information was recorded at 9:30 p.m. Now, there's a reference to Runi Khata PS GD entry number 535 at 27/10/2020. Now, the contents of the FIR is, this is to inform you that on 27/10/2020 at about 12:30 p.m., a reliable information was received that one person, namely so-and-so has been involved in selling narcotic substances. And therefore, what is happening, this JD entry, although I have not seen it, the reference to GD entry is made on 530, sale number 535. So this has to match with 12:30 when the information is received and recorded in the JD entry. Once that entry is recorded, that gives rise to the subsequent actions of the police. Now in the FIR, you will find somewhere that it is stated that we asked this number, the person number 3, to be a witness, and he agreed to be a witness. In this FIR, just let me find out. Yes, Suresh Narzari. So in the FIR, it is mentioned that he was asked to be a witness and then he agreed. In the evidence, he may say something else.
But then ultimately, it is the evidence.
No, it's correct. I'm not disagreeing with you. Yes, here is that entry, GD entry. GD entry is Exhibit 3. This is entered at 12:30.
Yes.
And this GD entry says, বিবিধ ব্যবস্থা গ্রহণ করার কারণে প্রয়োজনীয় অনুমতিপত্র অথরাইজেশন লেটার সংগ্রহ কৰিবৰ কাৰণে পাত্ৰ থানাৰ SI প্ৰণৱ কুমাৰ সোয়েনসোয়ে জিলাৰ মাননীয় আৰক্ষী অধীক্ষক মহোদয় কাৰ্যালয় কৰে. So therefore, he took appropriate steps for having the authorization letter to do it.
He got the authorization thereafter.
No, before that, 12:30. GD entry refers to 12:30. So the communication may have been late.
No, well, the GD was at 12:30, and thereafter he sought the authorization. He sent for authorization
Yes.
to the SP.
And the authorization is Exhibit 4.
So authorization came thereafter. The time is not there, but it was planned. Authorization came. And on the basis of that, he ultimately went there.
Yes. So perhaps what we can do is that we can expedite the making of the paper book.
But in bilateral submission, apparently there is no evidence. At least the evidence of PW1. only Caesar witness. He doesn't say that I came here to be the witness. It's a son's witness, basically. Therefore, it lacks credibility, and that is what the law says. Supreme Court says repeatedly that here you must take maximum precautions to ensure that it leaves no doubt that in fact this search was made, in fact this Caesar was made from there only, and there are sufficient. What is the language used? Can you see, madam? 50 subsection 5. Should I read it, my lord?
Which one?
Section 50 subsection 5.
Yes, yes, please.
When an officer, subsection 5, when an officer duly authorized under section 42 has reason to believe that it is not possible to take the person to be searched to the nearest gazetted officer without the possibility of the person to be searched parting with possession of any narcotic drug and psychotropic substance or controlled substance or article or document, he may, instead of taking such person to the nearest gazetted officer or magistrate, proceed to search the person has provided under section 100. The Code of Criminal Procedure. After a search is conducted under subsection 5, the officer will report the reason for such belief which necessitated such search, and within 72 hours send a copy thereof to his immediate official superior. So it refers to subsection 5 refers to section 100 of the Code of Criminal Procedure. Safeguards in making search. And 100 says at least to procure independent witness. Hundred, my lord. Persons in charge of closed place to allow search. Whenever any place liable to search or inspection under this chapter is closed, any person residing in or being in charge of and the place shall, on demand of the officer of the person executing the warrant and on production of the warrant, allow him free ingress into and afford all reasonable facilities for a search therein. If ingress into the such place cannot be obtained, the officer will execute warrant so and so. 3. Where any person is or about to place the reasonable suspect of concealing so and so women, that is finally come to 4. Before making a search, subsection 4. Before making a search under this chapter, the officer or other person about to make it shall call upon 2 or more independent and respectable inhabitants of the locality in which the place to be searched is situated, or of any other locality, if no such inhabitant of the said locality is available or is willing to be a witness to the search, to attend and witness the search, and may issue an order in writing to them or any of them so to do. 5 says the search shall be made in their presence, and a list of all things seized in the course of such search and of the places in which they are respectively found shall be prepared by such officer and signed by all of them. In that context only, I am contending, my lord, that PW1 is not reliable and cannot, the seizure is suspect. The whole seizure is a suspect. So here is a case where Lordship may have to hear and decide. But my response submission is, my lord, he is a pharmacist having a license. Sufficient bond can be given and he may be enlarged on bail so that he can continue to earn his livelihood. Any conditions, you will follow. তাৰপিছতহে এইটো কৰিব লাগিব। তেওঁৰ ওপৰতহে বেছি
It's not Mr. Masu, we hear, huh?
You might approach submission, but only one witness, this is PW1, that too is not independent. And there is no evidence either by PW5, the investigating officer, that I should notice, I informed them, these are due notices, and I brought them with prior notice, so they knew that I am going to search this and seize this. Nothing is right. Simply say,
Oh, but I'm not aware of that law. You'll have to guide us. Whether issuance of prior summons is required to have a witness appearing in a.
as per section 100(4), CRPC. In such cases, to ensure credibility, that there will be some independent witness, you should be told that we want you to be a witness here, not a such. Some person, he said that I suddenly saw some people, I went there, he took my signature, I saw some signature was made. It is purely, my sons, he came there. But law says that no, you must bring some people who are respectable inhabitants of that locality. And that should be told. This is how the contraband is there. We are going to search it. You come and witness.
We have few honorable people inside, respectable and honorable people.
Prima facie, some credibility is to be attested. Here, PW1, a person of 30 years, a young man. Others who are little older, they have not supported.
No, but the difficulty is, you see, even otherwise, we are not into Drug and Cosmetics Act, but under Drug and Cosmetic Acts, the Schedule A is a license to run a pharmacy. And then in Schedule A, we have a separate license for Schedule X. This nature of drugs are under Schedule X, under the Drugs and Cosmetics Act. And there you'll have to keep it only with having a prescription, a limited quantity. And if you have to exceed that quantity, then you have to take the permission of the drug controller to have that extra stock. And for that, there is again a requirement to have a register maintained of Schedule X drugs, and then periodical returns are to be filed if you are dealing with the Schedule X drug. And with some experience I have gathered, I can tell you, you see, there are two very emergency medicines which ought to be kept with the pharmacy, but they are not keeping it. As a result of which, you won't find it easily available. And that is injections called pethidine and morphine. If one has a heart attack, that is the first primary drug which has to be given, and then but it's not available because they are in Schedule X, and therefore those licenses are required to deal with it. That is one part. Now, if he is having a quantity exceeding the prescription of law, having a quantity of more than that, then he'll have to, when the raid was made, he could have still, in the trial or even today, he would have brought on record the documents showing that he had legally purchased it and was having it. Because if it's a pharmacy and he's storing it beyond a reasonable quantity, then he'll have to show us, because you see these drugs without there being a. I'll tell you, I have some experience in this, and that's why I'm telling you. No, not that. I'm just telling you. You see, when a licensee under Schedule A purchases drugs, he is bound to purchase it only from those persons who are having license under Schedule B. Schedule B is a wholesale license, and therefore a pharmacist who has the Schedule B can deal in wholesale drugs, and then it's a retail. And there is a requirement that if Schedule A pharmacy wants to purchase something from Schedule B wholesale, he'll have to give a what you call a requisition slip under his seal and signature. And if you ask a pharmacy, they'll tell you that supposing there's a drug dealer called A, B is requisitioning some drugs, he will send a requisition with a stamp and seal, and then against that he's transferred those drugs, sold those drugs, and which are through a memo. So therefore it's documented. And it's not possible that one will have a undocumented purchase made.
True, but this is the procedure. Normally, to change hands, these drugs, there must be record. And that is only authorized person. That is always required, but it is not happening in practice.
No, it's happening. Any pharmacy, be big or small. If you ask them, they will be in a position to show you the cash memos.
Not all, maybe.
All.
it is good if it's.
It's all, only 7 except those drugs which are infiltrated through black channel, like this drugs.
That's what the concern is, basically. And nowadays, that the drugs, those are not found mostly. The genuine drugs are not.
I'll tell you, there are 2 reasons why. Number one, there are one category of drugs which are life-saving, which have a short expiry dates. So unless you get it from a bill, you will not get a replacement. The pharmacy, if they have old drugs, they can return it. There is a requirement of returning before 3 months. So therefore, it can be replaced. But for that, you have to show them their this and batch number. Because nowadays, it's just general statement I'm making. Nowadays, if you get your drugs from any store who sell it through a particular e-way bill, you will find these batch numbers and expiry date also printed in the cash memos. Electronically prepared drugs, if you purchase, then you will also find the batch number and the expiry date. So therefore, even assuming that you have a tablet of strip of 5, out of which you have consumed 2 medicines, and 2 or 3 which are left does not have that expiry mark there. So don't worry about it now. You will have that from the cash memo. You can locate it, the expiry date will be there. So this is the what you call new bills which are now coming generated. So therefore, this is a requirement. Otherwise, these pharmacies will lose money. So that is primary reason why all the retailers will have a bill. I'm saying it's from some experience I've gathered.
Don't give it to the procedure unless asked. That is the biggest.
Oh, there is again the different aspect. I'll tell you why. I'll forget the amount now. I think it's not mandatory to have a GST bill created unless the purchase exceeds a particular amount. When I was in college, the amount of that was general sales tax then, they had a circular that purchases above rupees, below rupees 100 may not be given a cash memo. Because the question is that to print the cash memo and then to make the duplicates with carbon copy at that time, it would have costed more than the profit earned. If somebody will purchase 1 rupee and then say that give me a cash memo, the cash memo issuance will be costlier than the sale. And therefore, there is an exemption limit. There is an exemption limit under the GST that you don't have to give it. And therefore, you'll find in cash memos, they write cash and then sell it. At the end of the day, they will prepare a cash memo, cash sales made, and then it's a wholesale cash memo made and one entry that is permissible. At least under the GST Act when I was a kid, college going student, then till then GST had an exemption of 100 rupees. I did petty jobs and therefore gathered some experience there.
But normally, our people are not that learned or educated to ask for capital generally. Now, of course, most of them.
Yes, Ms. Chan.
In fact, section 50, I don't think so it will be applicable in this case. It is settled long back. That it is only applicable in cases where the body of the person is searched. Even a recent case, Lordship will find Chadha cases there. This is Ranjan Kumar Chadha versus State of Lordship can see this. There it has been in details after referring to so many cases. It was Ranjan Kumar Chadha versus State of Andhra Pradesh. There also, Lordship may go to paragraph.
CHA.
CHA-DHA.
State of Himachal Pradesh.
Or State of Himachal Pradesh, yes, yes. Lordship will go to the last paragraphs, 80 something. State of Himachal Pradesh. Lordship can go to 89 or so. there it is said that even the bag or the container, whatever that person is holding, even that will not be included in section 50. 50 is only with respect to searching the body. Paragraph 84, Lordship can see. 84, 85. Actually, the term person ought to be construed strictly. It starts with paragraph 81. Division bench of the decision of larger bench in Pawan Kumar came to in reference. In the said matter, opium was recovered from the accused bag upon a search conducted by constable. That will not be within section 50. Paragraph 83 says that the term person under section 50 would mean a natural person or a living unit, not an artificial person, bag or a briefcase.
Yes.
So any incriminating article, if it is kept concealed in the body or the clothing or the covering in the footwear, then those cases it will be section 50. But in our case, it is from a pharmacy and the things were inside a bag. It was recovered from there. So section 50 has no application. So as well, similarly, section 100 will also not come. Summoning some person, getting some persons. So we will be landed with section 42. So section 42, he got the information, he made a GD entry, he got the authorization, he searched, thereafter he had cracked, then inventory, then all those things are procedure, in my humble submission, is complied with. 50 cannot be gone into. Independent witnesses are there, 1, 2, 3, and 4. They went, of course, they saw a gathering, they went and they saw the tablets being brought out from the pharmacy, kept it on the table. So as far as recovery, on the information received, that is not disputed, it is there. And it is not from the person, he might be the owner, but it is from the premises, the pharmacy. PW 5 is there, the seizing witness, and a number of judgments. Lordship knows that even police officers are believed with in cases of narcotics, NDPS. We need not have independent witness. People do not come and depose. But here there are 4 who have said those articles have been received. And it is commercial quantity. These tablets, these are what? Tramadol. Tramadol is a psychotropic substance. Commercial quantity is 250 grams. And the recovered item, the quantity is 1,488 grams. So it is commercial quantity. Let the paper book be prepared, and because merit of the case, I have a strong case. (53)(b) and all those sections where inventory has to be, the photographs needs to be taken, inventory needs to be prepared. Those things we will see during the time of hearing. Those I have not found out in the evidence whether they have complied with 53A. On section 50, Chhatha case is very clear.
Mr. Madhavi, dictate the order.
I only pray, my lord, that there's a case where lordship may hear or other things, I'm not hearing, but he may, prima facie, it appears that it stands only on the witness one, PW one and PW five. Rest, whether it was sent to the FSL, how it was done, these things will come later, and I'm not going to this. But apparently, my lord, he is 6 months inside now. With stringent conditions even, he may be allowed to live, he will test. Ultimately, apart where it comes. Document can be done.
Heard. Mr. K.K. Mahanta, Senior Counsel, assisted by Mr. A. Boho, Counsel for the petitioner. Also heard Ms. S. Jahan, an APP for the state. Next panel. By this application under section 389 CRPC. The applicant has prayed for suspension of sentence and stay of realization of fine, and for releasing the applicant dash appellant on bail pending disposal of the connected criminal appeal number 310 of 2023. Next by the applicant was convicted of committing offense punishable under section 22 within bracket small c of the NDPS Act, 1985 by judgment and order dated 25/7/2023, passed by the learned Special Judge Chirang in special NDPS case number 5 of 2021, and he was sentenced to undergo rigorous imprisonment for 10 years with fine of rupees 50,000 with default stipulation. Next, the learned senior counsel for the applicant has submitted that on 27/10/2020, when a raid was conducted by the police personnel in the pharmacy of the applicant, the provisions of section 50 of the NDPS Act, 1985, as well as read with section 100 of the CRPC was not followed. It is in the said context, it is submitted that firstly, the raid was conducted between sunset and sunrise. But due safeguards are not resorted to for making a search within after sunset. Moreover, it is submitted that the before making a search, the police personnel did not procure attendance of two independent witnesses after putting them to notice that a search in respect of narcotic drug and psychotropic substances was to be made. Two respectable, huh? Two respectable witnesses. Was made by asking them whether they were willing to be witnesses to the search. And that prior to enlisting them as witnesses, they were not issued any order or notice in writing to be a witness. So accordingly, it is submitted that the search and resultant seizure stands vitiated by non-compliance of the provisions of section 100 CRPC read with section 50 of the NDPS Act, 1985. Next, it is submitted that the prosecution has heavily relied on the evidence of PW1, who was a seizure witness. First off, it is submitted that they said PW1 was a chance witness who had stated in his examination in chief that well as the exemption sheet that to the effect that he saw a gathering in front of the pharmacy of the appellant, and out of curiosity, he had gone there to see what was happening, and he saw police inside the pharmacy who were collecting capsules on the table of the pharmacy, and he saw those capsules, and the police requested him and two other persons to take seat and wait for some time, and thereafter the police took signature on a paper and packed the capsules in front of him. Full stop. Accordingly, it is submitted that he was merely a chance witness and not a witness duly informed about the seizure to be search and seizure to be conducted. That's why it has also been submitted that the applicant was about 6 months in jail during the trial, and then and since his conviction, provide impugned judgment and order dated 25/7/2023, comma, he is in judicial custody Accordingly, it is submitted that there may not be a chance of early hearing of this, of the connected appeal, and therefore the applicant be enlarged on bail. That is, seizure, there you have, it was further submitted that as the applicant was the owner of the pharmacy, and since a raid was conducted in his pharmacy, it would amount to search and seizure on the person of the applicant, and therefore it was mandatory to follow the procedure as laid down under section 50 of the NDPS Act, read with section 100 of the CRPC. So per contract, the learned APP has submitted that the Supreme Court of India, in the case of Ranjan Kumar Chadha versus State of Himachal Pradesh, reported in within bracket 2023, bracket close 0, INSC 878 equivalent to within bracket 2023, bracket close 0 Supreme, within bracket SC 1015, had held that sorry, relied on the decision of the larger bench of the Supreme Court of India in the case of Pawan Kumar. Sorry, State of Himachal Pradesh versus Pawan Kumar. Comma 2004, 7 SCC 735. Referred to its decision wherein it was held that the term inverted commas person under section 50 of the NDPS Act would mean a natural person or a living unit and not an artificial person, i.e. a bag or a briefcase. So accordingly, it is submitted that the that a premises, that a pharmacy premises cannot be read as an extension of a physical body of a person, so as to include the requirement of section 50 of the NDPS Act to be complied with. We next para, we take note of the decision of Pawan Kumar within bracket Supra, and the facts of the said case was that the search conducted was not only on the bag, but also of the person of the accused. However, the contraband was recovered only from the bag and not from the person of the accused therein. Full stop. Nonetheless, comma, since the recovery of the contraband was made from the bag and not from the accused person, comma, the Supreme Court of India took the view that Section 50 of the NDPS Act would have no application. Full stop. In the said decision of so-and-so Chadha, Supra, reference is made to the case of State of Rajasthan versus Daulat Ram, DAULAT, RAM, within bracket 2005, bracket was 7 SCC 36, where opium was recovered from a bag being carried on the accused person's apostrophe S head. So nonetheless, the Supreme Court of India, by relying on the case of Pawan Kumar within bracket Supra, held that the recovery made from the accused person's bag would not constitute personal search of the accused, and thus, comma, it was held that it would not attract Section 50. Full stop. Several other cases of cases are also cited in the said decision of so-and-so Kumar Chadha with bracket Supra. Next paragraph. Therefore, comma, the relying on the decision in the case of Ranjan Kumar Chadha, comma, Supra, not comma, Supra, comma, the court is unable to accept that the rigors, RIGOURS, rigors of Section 50 was required to be complied with for a search to be conducted on the pharmacy of the petitioner, applicant. And therefore they said the submission is repelled. Next paragraph. Insofar as the plea of the value of evidence of PW1 is concerned, comma, for the purpose of deciding an application under Section 389 CRPC, comma, the court would not venture into appreciation of the evidence and try to find out if the evidence would lead to acquittal, and then examine the the prayer for bail or suspension of sentence. Most of these said appreciation should be left while deciding the connected appeal. Next paragraph. We would also like to refer to the decision of the Supreme Court of India in the case of Surinder Kumar Antil versus Surinder Kumar Antil, where the observations of the Supreme Court of India is as follows. Next paragraph. Therefore, we find that as the applicant has not suffered in carcination of the period provided under section 436 capital A of CRPC, the ratio of the case of Surinder Kumar Antil within brackets Supra is squarely applicable, and therefore the applicant cannot be granted the benefit of suspension of sentence and or bail. So accordingly, the prayer for bail is rejected. At this stage, then in appeal, Mr. same K.K. Bhanta, senior consultant, assisted Ms. A. Boro, and as Jahan. Next paragraph. As the LCR is received, the registry shall expeditiously prepare the paperwork. Next, list after 4 weeks awaiting preparation of paperwork. Or Mr. Mahanta, if you accept, you can have the paperwork, all is typed. You can prepare it will be faster. You can do it, otherwise because the registry will take some time, and I'll tell you why. Mr. Mahanta, we are the registry people in this paperwork section. They are now assigned duty by this court to prepare SMS version of our judgments. So that is a priority job being done at the aegis of the Supreme Court of India.
Version of the judgment, so I didn't know.
Because
Yes.
the Chief Justice of India is of the view that local people should understand in their own language, because English may not be understandable to people who are those. So there's some landmark judgments of the court are being translated, and therefore
Not all.
all can't be done.
Mhm.
So that is taking some time. So we are now not confident about timelines in which the paperwork can be prepared. Although they are doing their work over time, but still there are some delays. So should I leave it to the registry, or you can wait? Okay. You just don't say that. On the prayer made by the Renaissance Council for the appellant, we permit the appellant to prepare a paperwork, which upon preparation shall be sent to the paperwork section for vetting regarding its correctness. List after 4 weeks.
Okay. Gotcha.
Item 4 with 5.
Yes.
But on the last occasion, my friend has already taken your lordship to the evidentiary part of the case. Because two persons have been convicted under 302, along with section 376, my lord, subsection 2, subclause G.
Just a moment more, just. Yes. We will again take a break. I'm sorry to, well, it's almost 12. We'll take a break and come back. Otherwise, we'll have to disturb your argument again in the midst. Just take a break. Otherwise, your flow will stop again. You were referring to circumstances that uh, your last submissions were, you were referring to Exhibit 5 motorcycle, seizure of motorcycle, which was produced by Numal Gogoi. And it was produced by Professor Saikia, who was not examined. Then you had referred that people saw Utpal Gogoi and the girl going out and coming back. And you were referring to PW1 and PW5, their cross-examination. You had also referred to PW567, who had seen Deepak and the girl going out, but did not give the time. You had submitted that whether they saw them going out for the second time was not in their deposition. Both circumstances you referred was the presence of other persons. That is, two boys who were referred to by PW7 in their cross-examination with surname Das and one Rahul Bora. So, and you were referred to suspicion of PW7 that these three killed the girl, correct? Fifth circumstance you pointed out was if Deepak wanted to marry the girl, there was no motive to murder the girl. And then you had referred to Rahul Bora, who said that he loved the girl.
In fact, all these submissions were made for Deepak Gogoi. My client has made all these submissions in the number 4, that is Deepak Gogoi. I'm referring for Numal Gogoi now.
Numal Gogoi is okay, 252. That is Deepak. Okay, Deepak. Okay. Then the sixth circumstance, then it's yours. 3 persons were arrested with the appellant, Lankeshwar Rajbangshi Ratan, alias Rahul Bora, and Deven Das, and Ananda Rajbangshi. They were arrested but not sent to trial. You are saying that that is why only the appellant was before the trial court and therefore witness is named only him. Correct?
Belongs to him, that is not there.
Please come again.
But he's saying that there is a chromosomal found on the body of the girl.
Okay.
But whose semen is that? There is no examination or there is no evidence to that regard to connect the appellant with the semen found in the body of the deceased. There is nothing to connect.
Yes. So in criminal appeal 184, you are referring to PW1, PW2, PW5, and Exhibit 5. at page 91. Numol Gogoi led and produced.
I've given a small two-page write-up. What write-up will show that my name in the entire record surfaces in 4 places. And I have paraphrased exact line as to what the particular witness has stated about me. It will
Okay.
kindly take up that write-up.
We have it.
Yes, it is titled as Evidence Against Numul Gogoi. Now, the first time my name appears at page number 11 of the paper book, my lord will see PW1, what he says is, I have quoted it. Later I came to know that 2 persons, Numul Gogoi and Deepak Gogoi, had killed her. This is where my name appears for the first time. Now, against this, my lord, what I submit is that, lastly, my lord,
You are reading whose evidence?
this is PW1. That is informant, father of the deceased.
Okay, later I came to know. Okay.
Later I came. So, my lord, this is an absolutely hearsay evidence, and he even does not say it is evidence from where he has come to. It's simply an omnibus statement that later I have come to know. In my respectful submission, my lord, these statements would not help the prosecution to convict the present appellant under 302 or 376. Because, my lord, he has no personal knowledge of this one. This is my submission, my lord, and moreover, he has also failed to identify the 2 persons, my lord, in the document. Second time my name appears by my name is uttered by PW2. It is at page number 12 of the paper book. Somehow I skipped the page number here. What he says, that is the brother of the deceased. What he says is that in connection with Rasna death, police arrested 2 persons, namely Numul Gogoi and Deepak Gogoi. Now, this also in my respectful submission cannot be construed as an evidence to connect the appellant with the alleged offense, with the offense. The third matter, where the third witness who takes my name is PW5. Now, here is what the last scene theory comes into play. Here at page number 18, he says, I saw accused Numul and accused Deepak along with the deceased girl at the site on the day of the incident. At what time, what date, nothing. The girl left the site of the function along with the accused duo in a motorbike. Now, my lord, as many as 3 witnesses testifies the last scene theory, that is PW 5, 6, and 7. Now, out of this PW 5, 6, and 7, my name is uttered only by PW 5, 6, and 7. My lord does not take my name. Hence, my lord, there is no consistent evidence in this regard as well. Then, the evidence of PW 5 with regard to last scene theory is vague, inasmuch as, my lord, no time even approximate and no date whatsoever is stated. My lord, whatever little I have read about last scene theory, time assumes some importance in the case of last scene theory, because if the time gap is more, my lord, then the last scene theory gets diluted to a great extent. I'll come to the judgments, my lord, whether last scene theory, if last scene theory can be the sole basis of conviction or not. My friend has taken your lordship to give judgments, so I'll just rely on 2 judgments. And the 4th place where my name appears is at page number 3 of my write-up, is at Exhibit 5, page number 91. Now, my lord, will kindly come to Exhibit 5, page number 91 of the paper. Your lordship, on the last occasion have checked it with the original record, it was in English. Because the word used were disclosure. The word used is leading and produced by the accused. Page number 91.
Yes, this is where we stopped on the last date. Numol Gogoi.
I'm just, because this is 5 line, 5 or 6 line, the season is contained of 5 or 6, I'll just read it. I, the undersigned, do hereby seize the below descriptive motorcycle on being leading and produced by accused Numul Gogoi, son of such and such, village such and such, at the house of Manik Tamuli, son of such and such, of such and such, with above noted case reference, the seizure is made in the presence of the below side witness. My lord, we kindly turn to the next page, page 92. These are the two witnesses. My lord will mark Manik Tamuli is examined as PW9, page 25. PW9, page 25. Kondorpo Tamuli is examined as PW11, page 28.
Manik Tamul is PW.
PW9. Page 25.
Kandarpa Tamul is PW.
11, 1. Page 28. Now, my lord, let's see whether Manik Tamuli or Kondorpo Tamuli, whether anyone takes my name. My lord, kindly page 25.
The witness may be like me. I see the lawyers every day. Every day I have to ask the names, I forget. But by the time I wind up, I forget the names of the lawyers, and this happens daily. And this happens with the lawyers whom I interact daily.
The lottery takes up 10, 15 APs daily, my lord, and therefore it's quite natural. However, when these witnesses, hardly they go to court once in a light year.
I don't know, maybe like me, short memory. That's why you see I make notes.
The lottery was referring his submission as my submission.
This is a short memory.
Yes, my lord, page number 25. This is the seizure witness of that motorcycle who, according to the seizure list, I led the police and produced it from the house of Kondorpo. In the presence of this page 25, PW9, that is Manik Tamuli. You know, Manik Tamuli says this. The incident took place about 3 years ago. A person by the name Profullo Soikia. However, this Profullo Soikia is not examined. Kept his motorcycle in our house and went to Dibrugarh police. Police seized the motorcycle. Police obtained my signature in the seizure list. Exhibit 5 is the seizure list. My signature, I do not know why the motorcycle was seized. So, my lord, the seizure list is not true. Because the seizure witness does not testify what is stated in the seizure list. The next seizure witness, page number 28, PW 11. Page 11. Page 28, PW 11.
Yes.
I would see what the other Caesar witness says. Exhibit 5 is the Caesar list wherein 5(2) is my signature. The incident took place about 3 years ago. Police came to the house of my nephew, Manik Tamuli. Police seized one motorcycle from the house of Manik Tamuli through exhibit 5. Such and such is my signature given at the time of Caesar. I do not know as to whom the motorcycle belonged and why police seized the motorcycle. No name of Numul Gogoi. No name of Numul Gogoi. Hence, my lord, the Caesar list exhibit 5 is not proved because the contents of exhibit 5 was not stated by the Caesar witnesses. Now, my lord, as far as the disclosure, because the court below has put some reliance on the disclosure. My lord, on the last occasion, my lord,
Just a moment. What is the date of examination of PW 5? Sorry, this PW 11? What is the date of examination? 28.
2015. 20th of August, 2015.
Cross-examining lawyer is someone like this. याते हैं signature पे. Doesn't tell you anything. You only bring to this.
See what's happening. No, 3 flags I put in. Right to Mr. Vishwas also, since it's an exhibit, we'll not be relying on it, but still you can go through it. This is the flag, correct? Look at the signature. You have seen the signature? In exhibit 5? Correct. Prima facie does not appear to be a signature, it's only a name and address. Correct. Now come to the second flag. Backside. Correct. Now see the second flag, that is the second signature. Because the defense counsel was not even aware what is happening.
Hardly any cross also made it.
You won't say anything, but apparently
Yes. This is name and-
people who are in the trial court must know what trial is about. Yes.
So, my lord, be that as it may, my lord, so this, and my lord, as far as this, the word apparently used in exhibit 5 is leading and produce. So, my lord, after the full bench judgment of this court, my lord, that the disclosure statement may not be in writing, but some witness must come and testify exactly what he said, so that it can be segregated and only that part which led to the discovery will be admissible. There is no witness, my lord, there are 17 witnesses examined, none have deposed regarding any disclosure statement made by the present appellant. In fact, in a reference case in the, by the Supreme Court, the Supreme Court has answered that now for disclosure statement, my lord, it has to be
The second is.
You see, my brother is absolutely right. You see, none of the witnesses we have read so far said that the victim was taken by motorcycle, particular motorcycle, giving the number plate and identification of the motorcycle. That is not given. So even if it is produced, unless it is linked with the offense, we really don't want to touch that because although we are not stopping you from arguing that, but you see the question of leading to recovery, because leading to recovery is something which may not be from that witness, but it would be from the statement of the IO. IO is with PW 15.
Nothing is there.
Is not there.
Page 32.
One motorcycle was seized through so and so. It doesn't say that.
So therefore, my lord, this also goes, my lord. Exhibit 5 also goes. It cannot connect the appellant with the offense. This is by and large, these are my grounds, my lord. This is my submissions also, my lord. Because none of these 4 pieces of evidences is sufficient, even cumulatively or independently, to convict a person under 302 and 376. My lord, 1 or 2 quick points that I'd like to just rely upon. My lord will kindly see the postmortem report for.
Which page in the paperwork?
Yes, my lord. Postmortem PM report is 95. 93 onwards, 95 is the, I'd like to rely on 95. The injury is in the temporal region, my lord. Now, the skull, a round shaped swelling, page number 95. Pranam and spinal canal, skull, vertebra. A round shaped swelling size of 7 into 5 into 1 cm is present in the occipital region on discretion clotted blood seal. My lord, what I am submitting is that, my lord, there is no explanation of any injury in the sense whether it is caused by blunt weapon, sharp weapon, or it is a inside wound. It simply says swelling. It is very unnatural that if somebody wants to kill a person, will use some weapon. There is no weapon. Weapon recover. No weapon is recovered. Even there is no injury by any weapon. In all probability, this lady must have fallen somewhere, and that is why swelling in the occipital region. In all probability, because otherwise, my lord, to whatever postmortem report or medical evidence we have seen, my lord, in other cases, an opinion is expressed that it is injuries by blunt weapon, sharp weapon, inside wound, lacerated wound. It simply says swelling, and the opinion your lordship will find at page number 98. In my opinion, because of death is due to it should be cause of death. In my opinion, cause of death is due to neurogenic shock following injury to the vital organ, that is brain. The injuries are antepartum in nature and within 24 hours from the time. This is one part. The other part of the postmortem report is at page 97. Page 97, point number 11. Hello, may I read? Page 97.11.
Yes.
Organs of generation external and internal. Healthy and vaginal swab taken and handed over to the escorting IO. No vaginal or extra injury present in the vagina. Vaginal canal is loose. No injury because there is 376, and which is why I am indicating this one. No injury is found.
Yeah. We'll break at 3 o'clock. There's a single bench. We'll be here till,
There is a matter, timing matter, Lordship, item number 1. Item number 1, Lordship.
Yes,
timing matter,
yes.
That was fixed on at 2 p.m. Lordship.
Yes.
Now that is present. Lordship. So already service has been duly served upon respondent.
Okay.
So I have kept the paper on record.
Item 1. Okay. So we appoint our Marcus and then proceed with the matter
I'm there as the.
for the appellant. But Mr. Y.S. Manant and counsel for the appellant, Ms. S.S. Boral and APP has produced the service report in respect of respondent number 2 through the inspector of, through the officer in charge of Hajo Police Station, indicating that notice was served on the respondent number 2 on 29/1/2024. Post as respondent number 2 is unrepresented.
I think it was served yesterday,
Yes,
29/1.
yes.
I don't know whether
Lordship,
they.
the matter may be fixed after 2 weeks.
1 week or so that they appear.
In the meantime, Lordship.
Hardly.
29/1. Okay. So accordingly, we are inclined to wait for 2 weeks so as to enable the respondent number 2 to appear, filling which the court may appoint an amicus curiae to represent the interest of respondent number 2 on the next date. List after 2 weeks, give a fixed date after 2 weeks. Yeah, this service report, scan copy of the service report is kept as a part of the record.
Much.
Obliged.
Yes.
My lord, I'll just take another 5 to 7 minutes, my lord, to conclude. My lord, the judgment which I was referring, 2023, volume 6, SCC. My lord, I want to press in service para 82, which is at internal page number 766. Because that probably squarely covers the situation we're confronting in this case. my lord.
Para
Para 82.
82.
The SCC citation.
Yes.
This squarely covers the factual situation where we are confronted in the present case, my lord. Para 82 I'm reading. In cases where the victim of rape is alive, and my lord, this is in the context of 53A of the CRPC. my lord. In cases where the victim of rape is alive and is in a position to testify in court, it may be possible for the prosecution to take a chance by not medically examining the accused. But in cases where the victim is dead and the offense is sought to be established only by circumstantial evidence, medical evidence assumes great importance. The failure of the prosecution to produce such evidence, despite there being no obstacle from the accused or anyone, will certainly create a gaping hole in the case of the prosecution and give rise to a serious doubt on the case of the prosecution. We do not wish to go into the question whether 53A is mandatory or not, Section 53A enables the prosecution to obtain a significant piece of evidence to prove the charge. The failure of the prosecution in this case to subject the appellant to medical examination is certainly fatal to the prosecution case, especially when the ocular evidence is found to be not trustworthy. And in my case, there is no ocular evidence.
Yes.
This is, my lord. So therefore, my lord, I have got nothing much to submit. The 4 pieces of evidence which I have jotted down in this 3-page write-up, my lord. This cumulatively or independently, in my respectful submission, is not sufficient to entail a conviction under 302 or for that matter 376. And the other piece of evidence which the learned public prosecutor before rising of this court was indicating, that is the 164 statement of PW5. My lord, 164 statement of PW5 was never exhibited. It was not brought to the notice of it was not exhibited. So that is then moreover, my lord, that disclosure of that my client's name came up in that exhibit, which saying that I have lead and my lord, even the content of exhibit 5 was not even put to my client in 313 examination. The content was never, so it cannot be used against me.
Let us see that.
Yep.
313.
313. My lord, may I straight away come to page 51, question number 9. That I led to the recovery, this question, this factor was never put to me.
PW9.
Question number 9, my lord, may see, page number 51. This is
No,
the-
he is PW5.
his PW9, Manik Tamul stated.
No, no, no. This is of whom?
This is
This is appellant.
appellant.
No, Numal Gogoi. Okay.
Yes. My lord.
Please repeat again. In question number 9, what he did not do was
That the fact that,
leading to recovery was not put.
yes, leading to recovery.
Yes.
So, my lord, in substance, my lord, in addition to the discrepancies that we have seen in the evidence, my lord, no weapon recovered, no motive attributed, non-explanation of the injuries, non-examination of Profulla Saikia, that is from whose possession that bike, who kept that bike, non-compliance of 53A. My lord, all these, in my respectful submission, will only ensure acquittal of the present appellant, my lord. My lord, that is what, and in my write-up, my lord, I have already given, I'll not repeat it, my lord. In my write-up, I have given one judgment. If your lordship kindly takes up my write-up at page number 2, I have paraphrased the relevant paragraphs of the judgment for convenience of this court, my lord. Page number 2. Here I have referred Kanhaiya Lal versus State of Rajasthan, 2014 4 SCC 715, para 12, exactly para 12 I have quoted in my write-up. And so, and hard copies of all these judgment I have already given to this court, my lord. Para 12, my lord. The circumstances of last seen theory does not by itself and necessarily lead to the inference that it was the accused who committed the crime. There must be something more establishing connectivity between the accused and the crime. Mere non-examination on the non-explanation on the part of the appellant in our considered opinion by itself cannot lead to proof of guilt against the appellant. So clear ratio laid down, my lord. Then the present judgment, which I have already taken to your lordship, the 2023 judgment. And there is one 2016, one SCC 550 at page 3 of my write-up, my lord. Nizam versus State of Rajasthan. Here also, my lord, the Honorable Supreme Court has overturned the judgment of conviction, which was based on the last seen theory, and para 19 is relevant, which says that in the case of circumstantial evidence, the court has to examine the entire evidence in its entirety and ensure that the only inference that can be drawn from the evidence is the guilt of the accused. In the case at hand, neither was the weapon of murder nor the money allegedly looted by the appellant or any other material recovered from the possession of the appellant. There are many apparent lapses in the investigation and missing links. And as far as, my lord, the disclosure statement, my lord, I have already given the citation. I am relying on 2009 2 GLT 414. That is a full bench judgment of this court, my lord, which says that if not in writing, somebody will have to testify the exact words. The relevant para also I have given, para 27 and 47. Then there is one more judgment of the Supreme. In fact, this is a reference which was made criminal trial guidelines regarding inadequacies and deficiencies. Supreme Court has laid down certain guidelines, and para 11 of this full bench judgment, this is also a full bench judgment, it says that disclosure statement has to be separately exhibited. That only that part which leads to discovery. Then 313, since it was that particular part was not put on 313, here I put reliance on 2011 8 SCC page 80 para 21 and 22. The Caesar list exhibit 5, namely such as this para, they say that if an evidence is not put to a accused at the stage of 3 and 3, then the same cannot be taken into consideration. My lord, this is, I sum up, my lord. So in view of the arguments made, my lord, I humbly pray that the present appellant will be executed and they are on bail, my lord. At the appellate stage, the division bench has already granted bail. I am deeply aware.
Yes.
Lordship, this is an appeal against conviction whereby the accused was convicted under section 302, 34 and 376 subsection C of IPC law. And the prosecution case nutshell is this. The FIR was lost by the father of the deceased, that is informant who happens to be the informant in prosecution PW1. He has deposed it on the date of incident, that is on 23/03/2012. The victim came to attend one cultural function to Lhasa along with her companions. And after having finished of the function, the other companions came back home, but she didn't return home. And when the informant, the father of the victim girl, asked the companions about her whereabouts, then they replied that The victim has been disappearing since 8:30 PM on that fateful night. On the following day of the occurrence, the village headland of Chelua, where the function was taken place.
Just a moment. Yes,
The village headland of Chelua village, where the occurrence took place, informed that the victim's dead body has been recovered. And after receiving the information, he went to the place of reference and he saw injury marks in the backside of the head of victim's dead body. Thereafter, he identified the body and before his arrival, police has already went to the spot. And thereafter, he lost a FIR. And as per procedure, SDC held the inquest report on the dead body. And accordingly prepared the inquest report. And later he came to know that two persons, that is the present accused who has killed her. And his daughter-in-laws, namely Anu Dole, Dipti Dole, Savita Dole, and Deepak Kukul is one of his sons. Came down from the stage and they have told him that the accused Deepak Gogoi, he called the victim from the stage and asked her to go to the market site. And thereafter, again, the victim returned with the accused and giving some charges to the companions that happens to be the daughter-in-laws of the informant, that they need not look after her because she's leaving the place and she was planning to get married with Deepak Gogoi. Thereafter, Lordship, at night hours, after not reaching her home, they have found her dead body in the next day. So the entire prosecution case is based on circumstantial evidence. There is no eyewitness. Lordship, to that effect, I'd like to place my submission and I'd like to rely on the depositions of PW1, PW5, PW6 and 7. And so far as PW1 is concerned, also I have already given the facts, the prosecution story in answer. And Lordship, I'm just coming to page 10, Lordship, that is PW1. The statement is like this: I do know the two accused persons present in the dock. This is Rasna, the victim was my daughter. The incident took place on so and so date. On the night of the incident, victim came to Kulajan to watch a festival with Anu Dole, Dipti Dole, Saurabh Dole, and Savita Dole. All others returned home after watching the.
just a moment.
Lordship. Yes. The following day, the village headman of Jelwa informed that victim's dead body had been recovered. On receiving the information, he went to Jelwa. I saw injury marks at the backside of the head of Rasna's dead body. I identified the dead body of the victim. I found police at the spot and lost an Najahar. Subsequently, police questioned me and recorded my statement. The SDC held inquest on the dead body and prepared inquest report. Exhibit 2 is the inquest report, wherein Exhibit 2, subsection 1 is my signature. Police took away victim's dead body for postmortem examination. Later, I came to know that two persons, the appellant, that is Numal Gogoi and Deepak Gogoi, had killed her. My daughter-in-laws, namely Anu Dole, Dipti Dole, Sabita Dole, told me that Deepak Gogoi had come down from the stage and called my daughter away to the markets outside. After a while, victim returned and giving daughter-in-laws chanas to munch. She left the place saying that they need not look for her. My daughter-in-laws told me that she had gone to get married to Deepak Gogoi. Police seized victim's broken mobile and a SIM card. Exhibit 3 is a Caesar list, wherein Exhibit 3(1) is my signature. And the cross part is, I was in Silapatra on the night of the incident. Learning about the incident over phone the following day, I came home and got to know about the incident from my daughter-in-laws. I met my daughter-in-laws Anu Dole before lodging the Azahar. I did not mention in the Azahar. I'm just coming to the relevant part, Lordship. It is not a fact that my daughter-in-laws did not tell me that accused Deepak Gogoi had taken along the victim Resta with him. It is not a fact that Deepak Gogoi is not involved with the case. It is not the fact that I have adduced false evidence. The fact is that she went to attain the cultural function along with the companions, who is the prosecution witnesses, that is 5, 6, and 7. And they have seen that Deepak Gogoi and Numal Gogoi was present at that relevant point of time. So in his cross-examination also, he remained consistent. He found to be consistent and firm so far as Deepak Gogoi's presence is concerned. That is totally unshaken by the defense side. Thereafter, I'd like to come to page 14 of the paper book. That is PW3, who is the village head membership. My name is Umesh Begu. I do not know the accused duo. I don't know complainant Tuniram Dole. I don't know the victim. One night in the month of March in 2012, as I was sleeping in my house, one person informed me over phone that a girl was lying dead on the highway near Jelua village. I immediately went to the spot. I saw a girl lying dead at the place of occurrence. A large number of people had gathered there. I don't know as to how the girl had died. I informed police of the incident over phone. Police recorded my statement. In cross, he declined. Thereafter, Lordship, kindly come to page 5, page 18, PW5, who happens to be the most vital witnesses, and he is the independent witness in the prosecution case. His name is Vinod Kuli. He deposed that I know both the accused persons. The incident took place in 2012. A girl was lying dead on a road in our village. Police came for investigation. Then I came to know that the girl was the daughter of Tuniram Dole, that is PW1, the father of the victim. On the day of the incident, Aliyalinga function was going on in Kulajan. I saw accused Numal and accused Deepak, along with the deceased girl, at the site of the function on the day of the incident. The girl left the site of the function along with the accused duo in a motorbike. I do not know as to how the girl died. Police recorded my statement. I made statement before the magistrate. He deposed while he was cross-examined that on the day of the incident, at first, accused Deepak and the girl went somewhere on a motorbike. Later, both of them returned. It is not the fact that after returning, accused Deepak did not go out with the girl again on a motorbike. It is not a fact that I did not state to the police that I had seen accused Deepak going out with the girl. It is not a fact that I have deposed falsely, that I saw accused Deepak with the girl. Cross-examination for the accused Numal Gogoi. It is not a fact that I had not seen accused Numal Gogoi going out with a deceased on a motorbike on the day of the incident. It is not a fact that I have adduced false evidence. I don't know as to how the daughter of Tuniram died. Here also, PW1, the statement of PW1 is corroborated by the statement of PW5. that the girl was last seen with the accused duo. And when she left the place of occurrence, place of function, she was also, both the accused persons were found to be present with the victim when she was alive. That is remained unshaken, and there his statement is also remain, PW5 statement is remained consistent, found to be trustworthy because it remain, could not demolish the statement of the PW5 in a material part. That's C, both the persons were present at that relevant point of time. Then I'd like to come to page 20, Lordship, that is PW6, Sabita Dole. Lordship. PW7, that is page 22. I know the accused epoch.
PW6.
7.
No, PW6 you did not complete.
Yes, yes, yes. Lordship, again, I have to, from the very.
So just highlight it because
Yes.
there we have a question there.
Yes. Accused epoch called Rasta away when we are watching the function. And in his cross, in her cross, while making statement before police, I did not state that accused epoch. It is not a fact that I have adduced falsely in the court today that accused epoch had called Rasta away.
Yes. No, just pause for a moment. Please come to page 11. This is evidence in chief of PW1. About 8 lines from above.
Yes.
7 lines in fact. Later I came to know that 2 persons, Nomal Gogoi and Deepak Gogoi, had killed her. My daughter-in-laws, namely so and so, told me that Deepak Gogoi had come down from the stage and called Rasna away to the market outside. Correct. Now this PW6 you are reading is Sabina Dole. She is that third lady referred to by PW1. She does not say that I informed this Tuniram Dole. Therefore, you see, Tuniram Dole is a hearsay witness. If the main the person on whose statement he has relied does not depose that she had told Tuniram. Is the evidence can you say that the evidence is connected
PW,
or reliable?
with PW1, was it the corroborative?
No. If PW6 does not say that she informed Tuniram,
Yes.
that means what is the evidentiary value of the statement of Tuniram who says that I was told by these 3 ladies?
Lordship, then kindly come to page 22.
22.
PW7. Deepak called away, Rasna outside. That is third line. Has your lordship got it? I know-
Yes.
I know accused Deepak. Victim was my elder sister. The incident took place about 3 years ago. I, along with my wife and victim, was watching function at Kulazan. Deepak called the way, victim outside. Tell us that she was going to marry Deepak. Then she went away, leaving us at the site of the function in the morning of the following day, finding victim's dead body lying on the road. When people informed us, father and mother went to the place of occurrence. They found victim's dead body, father had lost a complaint with the police station. Therefore,
This also doesn't help because you see what happens is that PW6 is the wife of PW7. Now, PW7 says that he was present there. The PW1, if you come back to PW1, he does not say that the son has informed me.
But that is not there, but
No, you
maybe-
see, is it not unnatural?
see, it's there, lordship. He has stated that Anu Dole, Dipti Dole, Saurabh Dole. Saurabh Dole is PW7.
You're reading where?
Lordship PW1, page 10.
10.
Yes.
No, he was with there. It's not
was-
that.
yeah.
But you see, the father gathers information not from the son, gathers information from the daughter-in-law and two other ladies. What is the relation I have not seen? This is something which is not normally happening. Son not informing and the daughter-in-law informing that she had taken away. That is one part. The second part is that you see, we are evaluating the evidence of PW1 vis-a-vis PW6.
Lordship.
What we're trying to ask you is that if the main witness, which is PW6, does not say that she has informed Tuniram, what is the source of information of Tuniram? So therefore, the evidence of this Tuniram PW1, whether can be said to be reliable.
Perhaps that question, that suggestion was not put to her.
This victim was of which community? Missing. Any learned counsel here from that community you can think of? You can just recollect any names who might be available in the court right now.
He didn't pay.
Girin Pegu. Just give the scroll Girin Pegu. Advocate. It's okay, you proceed. We have some queries.
Basically, the prosecution case is based on circumstantial evidence, as
Hmm.
well as circumstantial evidence, as well as evidence that is as regard to the victim last seen alive, the accused to. So to that regard, the incriminating circumstantial evidences, so I'd like to place in a chronological manner. Number one, Lordship, PW1 deposed on the date of occurrence, that is on 23rd.
We'll come the other way. You see, I'll tell you the source first and then say, come to page 73. Seventy-three are the circumstances where the court has
Yes.
referred to, and these are the basis on which conviction was made.
Yes.
PW1 is not relied on.
What is 6 and 7?
Yes,
That at the time of occurrence.
means we are not stopping you from arguing, but we are trying to say that when we are hearing you, we are correlating it with something.
Lordship.
So PW1 is something which is not relied upon.
PW 6 and 7 is.
In the body, if it is relied, I don't know. But
Lordship.
this highlighted portion does not say PW1. But inside I have not gone.
6 and 7.
Huh.
Yes. So on the date of occurrence, that is on 23rd/03/2012, PW 6 and 7 went to the place to Kulajam to attend the function, and that is not at all disputed by the defense side. And they have stated that both the accused were present with the deceased person, and they have saw him at the time of, before the time of occurrence. And that is also not disputed. Thereafter, Lordship, PW 5 happens to be the independent witness.
No, you see, there's a relevance here. Let us tell you what has happened. Come back to PW1.
Lordship.
Page 11.
Lordship.
After last 4 lines of the chin chief, after a while, Resna returned and giving daughter-in-law's chanas to munch. She left the place saying that they did not look for her. My daughter-in-laws told me that she had gone to get married to Deepak Gogoi. So that means what Mr. Ahmed and Mr. Viswas are both saying is that first part is okay. She went and came back. Second is that she is now going to get married to Deepak Gogoi. She is leaving. So this is the second part when they are left. So unless somebody can give evidence to that effect that for the second time they saw living together, then it is acceptable, because now this 3 girls, the ladies, daughter-in-laws, the Anu Dole, Dipti Dole, and Sabita Dole, they are now aware that he is going for the second time. So the evidence which is being tendered, is it for the first time or the second?
Second time also, PW 5 is very much consistent to that effect.
PW
5.
5.
Page 19.
Page 18.
Is
19.
19, relevant pages. On the day of the incident, at first, accused Deepak and the girl went somewhere on a motorbike. Later, both of them returned. It is not a fact that after returning, accused Deepak did not go out with the girl again on a motorbike. And cross-examination in respect of Numal Gogoi Lordship. It is not affected. I had not seen accused Numal Gogoi out with the deceased girl on a motorbike on the day of the incident. Not affected. I have 18 false evidence. That is relevant.
In chief of one is the process and component. Payment is very question.
Yes, Lordship.
Yes.
Thereafter, Lordship, PW5 is very much consistent and remain unshaken by the defense so far as he has contended that he saw the accused duo along with the deceased girl alive at the site of the function on the day of the incident. And a second time also, he has reiterated the same thing that both of them were present with the accused. Lordship. And thereafter, Lordship, PW5, in his 164 statement, stated that he gave the motorbike to accused Deepak Gogoi Lordship. And after that, Lordship, the dead body was found lying on the road with multiple injuries on her head. And that is also supported by the medical evidence that is PW 15 motion. At page 32. As PW 10 motion at page 26. On 24/3/2012, I was at Hemazi Civil Hospital. On that day, I performed postmortem examination of the dead body of the victim. The dead body was identified by so and so. Now I am coming to the opinion. The external appearance, the dead body was stout curl, rigor mortis was present, an abrasion was present over the 8-9 joint on back. Whole face was stained with blood and clothed. Clotted blood was also seen on the nose. Cranium and spinal canal, a round shaped swelling, size 7x5 to 1 cm is present over occipital region. On dissection of the gall, clotted blood was seen and hematoma. Hematoma was also present. Both temporal part of right and left Louis was in color. After dissection, tear of the membrane on occipital region underneath hematoma was present. On the occipital region, the hematoma was present. Abrasion was present on the occipital region of the brain, which was corresponds to the hematoma. And as per opinion, in my opinion, the cause of death is due to neurogenic shock following injury to the vital organ, that is brain. And the injuries were antemortem in nature. It's occurred within 24 hours at the time of examination. That is also supported by the inquest report that Lordship will found the exhibit page 85, inquest report, Lordship, exhibit 2. That is, Lordship, last 3 lines, Lordship. Major injury mark was seen at backside head and blood was seen at the head, whole of the face. So that is the vital, the injury was sustained by the victim on the vital part, that is on the brain. That is also supported by the inquest report. Thereafter, Lordship, scientific opinion, that is PW 17, Lordship. A positive place for human spermatozoa that is found after vaginal examination of vaginal swab of the victim. The Lordship has made a query just before rising. Lordship, whether some queries has been raised by a Lordship regarding how it is sent at the date of duration of time. So let's say kindly come to the LCR, Lordship. I have flag marked page 17. Pink flag, Lordship.
I see. Oh, yes. We are hearing a matter where one of missing tribe, what do you call, culture we wanted to understand. Can you tell us something about it? Miss, huh? Ali Ai Liang. It's basically an agriculture what do you call festival, like Bihu here. You celebrate the agrarian what do you call product which comes out, and then therefore it's celebrated. in that community, in your community, in fact, is that the day where boy and a girl can run away from the home and get married?
There is no bar as such because
No, it's not a question of bar, it's a question of practice. You see, a certain day, maybe it's possible that the community permits people to elope and marry. So is this festival attached to that? No.
in our tradition, my lord, marriage by elopement, that is.
No, that is permissible. So no objection with that, but
This
but
is
in
the
fact,
occasion where we sow the this
seeds.
seeds, yes, ma'am.
There's
So
a sowing
if somebody
season.
marries on that particular day, then
It's not a acceptable practice, but one can do it.
one can.
Okay, thank you only for that reason. Thank you. Thank you. Now you see the relevance of PW1. Come back to PW1. He says that my daughter-in-laws told me that the girl says, don't look for me. I'll be running away. I'll be marrying Deepak. That's her statement. And therefore, everybody takes it casually. Nobody inquires. She's found dead on the next date. This is something which was coming in my mind continuously. Because if that is not the practice of the community to get married on that sowing season, then this is something which should have been flagged. Somebody should have been anxious in the home to try to find out the girl, but nobody did so. That is the only reason we wanted to know about this culture. If on that particular day marriage is permissible by elopement. So elopement can be permissible, is permissible because every day now we can elope and get married. There's no bar with any religion or any caste or community. You can just elope and get married.
In our community, Assamese community, they will Bihu worship in the month of April. So people, naturally, children, they went out for eloping.
No, you can.
Yes.
No. You see, we won't say anything because you see it's a accepted what you call facet of the life now. So there's nothing to say about it. But it's only the particular day, if it is permissible in a community where people would take it for granted and will not pursue the girl. You see, if somebody tells me that, well, I am going and I am going to get married with a don't search for me. Either what I'll do is that if I'm the guardian, I would get her married. Number two, if I'm not, I'll attend the marriage. But if a girl in my family tells me that I am going alone, getting married, this is something which is otherwise not accepted, what you call, customary behavior. Because somebody telling me, if I'm a guardian of the girl, somebody tells me that even if I'm not a guardian, if X also tells me that, well, I'm going to run away and get married, I would just say, wait, let me come. Because somebody must be there to take care of the situation. This is something which is unnatural and was flagging us.
Normally, the village people seems to be very casual with a boy.
I don't think so. I have not met a guardian who is so casual.
Happens for him sometimes, Roshan. Yes.
I won't say. Because in that community, if it is a practice, then we will not search for her. But if it's not a practice, then definitely guardians coming to know, you see the daughter-in-law coming and say that, well, your daughter has fled away and doesn't flag the father.
Might be the other companions they came back from the function.
Pardon me?
Might be the other companions who has come back after attending the functions, the other companions of the deceased who came back home.
We don't know from the evidence. It is not there. She had companions or not. We don't know. We're just trying to understand the scheme. We'll continue day after tomorrow. Because we'll have to break, both have single bench. The Mr. A. Hamid, counsel for the appellant in criminal appeal 252 of 2018 is present. The submissions of Mr. M. Biswas, learned counsel for the appellant in criminal appeal 184 of 2018 is concluded, concluded, full stop. The learned counsel for both the appellants have reserved the right to reply. Next paragraph, the submissions of Ms. S.H. Baral and APP remains inconclusive. Please stop a day after tomorrow. First of February, as a parted matter.
The Lordship put a query how that DNA has to be preserved. It is there in the Modi's medical.
Modi's medical, yes. Modi's medical, right. Modi's medical jurisprudence. Earlier it was a bound volume bluish green.
The forwarding report is required and there are very certain procedure how it has to be preserved.
Oh, okay. So that's why, because you see, that's why I said, because earlier that book was a big bluish green book. Now I read that long back. Maybe I am recollecting it after 20 years. But you see this procedure of unless you see unless the seizure is proved, and the when it is sent for medical examination, sorry, forensic examination, then we have to have a what is called chain of custody. That has to be shown. Otherwise, this forensic lab report will be a doubtful. Unless if the chain of custody is broken. That's why we just.
For drawing samples.
Hmm?
Even there are guidelines for drawing samples.
Pass me that book. I have to refresh my memory again now.
Subject to correction. So far as 110, page number 110, Worship, the date of giving opinion that is on 5/5/2012, and date of sending the sample that is on 27/3/2012.
Yes, 27.3. It was, no, you see, sending is something else. But this sample doesn't work of its own.
Worship, that is what I kind of thought.
No, you see, there only it says received by the office on 30. That means it was sent somewhere and it has come, because you see, otherwise they have not taken a defense. But the question would be, if the chain of custody is broken, then whether it is sample A which is collected was sent for examination, or it is sample B which was examined, or it was a new sample altogether. There was no sample at all. They just created this evidence. You see, once the custody is broken, chain of custody is broken, then nothing happens. That's why we were asking that question, and we are referring to this Modi's.
What was Captain Halki Raki, sir?
You see, we are thankful that you got this book. In fact, you will find here seminal swabs. A dry cotton swab should be placed in a clean dry glass bottle.
Yes.
So it should have been a cotton swab which had been seized. Taken and the sample should have been kept in a dry bottle. And then there also the report will say that we have retrieved what from that bottle. This is to be retrieved and that was examined. So therefore we are missing something in between.
PW10 is PW10 lordship.
Yes.
PW10 lordship, page 27.
27. Yes.
Lordship. the last 3 lines. Mm, Vaginal swab and uterus was handed over to the IO. That is vaginal, the semen has been extracted and it is handed over to the IO. That is on 24/03/2012.
The date of death is
The date of death is, the dead body was found on 24/03/2012.
24, 2012.
12. Yes. And it was handed over to the IO. That is on the same day, Lordship.
No.
Viscera surface stomach, kidney, liver, and vaginal swab, and uterus was handed over to the IO. Then, Lordship, the challan for use when a dead body is sent for examination,
Pardon me?
there is a pink flag, Lordship, kindly in the LCR.
In the LCR.
Yes. That is the challan that is used when a dead body is sent for examination. That was on 24/03/2023.
Yes.
After their Lordship, they have sent it on 27/03/2012. And the Office of the FSL Forensic Laboratory has received the SAT
On 30,
on 31/3/2012.
yes. Where is the, which page is the, what do you call this, postmortem report?
There is no, that is not under challenge, that the chain of custody has been breakdown. That is also not challenged.
No, no, you see, somebody has given this, this document you showed, somebody had given it to the IO. I would, when it is seeing it, he'll make a memo. And therefore it is that swab which has come in and it is sent. So therefore this sample would be, this swab would be kept in the bottle sealed. And then this entry is made and therefore that has to be proved that chain of custody is only that.
Disputed.
No, question of dispute doesn't come. It's a question of the admissibility of the evidence. This was not even, nobody had asked that question. So question of dispute is not there. Nobody asked that question to the IO, therefore there is no cross-examination on the point. But the question is, at this stage, we are hearing the appeal against the conviction. Now, if the chain of custody is not shown, we will find fault there. Which swab had actually gone into that, what do you call this, bottle, the Caesar, there has to be, everything has to be, you see, in a food case, we know how the samples are to be taken. The samples are taken, those are sealed in presence and then they are marked as a document stickered, and then those are sent for the laboratory. Memos are prepared about seizure. And that is entered and therefore the chain of custody starts from there.
Lordship, that is not exactly seized, Lordship. That has been extracted by the medical officer, Lordship.
No, medical officer, but is that the same swab which has gone there? If I am asking that question, what would you reply?
That has to be
Because that is the chain of evidence, because the chain of custody has to be unbroken. Because if I am asking a question to you that whether this is the swab which was given to you, then the answer would be no, because of the fact that we can't say, or rather, because of the fact that whether same was kept into the bottle, that evidence is lost.
We'll see the contents of the case diary now. The next state question. Whether the IO has kept the samples in the Malkhana.
Because if it's not there, then this chain of custody which is broken, then the evidence becomes unreliable. Because only when you put that into evidence, then only somebody can cross. If you put that in evidence, then only somebody can cross. And then they will demolish that it was not sealed properly, it was not taken properly, it was not packed properly. Other matters will be adjourned, Mr. Kamar. You were unwell.
I just wanted to repeat the accommodation. That's what
No, I told we'll give that accommodation.
That's one aspect, but the words they use is not good, no, madam. So I was telling my learned senior friend also, he was cautioning me. I don't know. I never said I am sick.
I would have.
I was telling him, get well trained from your, my assistant counsel told him, no.
No, we have we have highest regards for you, Mr. Kumar. No, we have highest regards for you.
If I'm
Yeah.
telling you,
No, I said
your
because
officers are always accommodating, understanding the lawyer's problem.
I was there.
Yeah. Even then your lordships also. know
Uh,
that. Other lordship also. We lawyers normally.
No, all matters will be adjourned. I'm not passing any
Only thing
orders.
is that mine needs a bail petition basically, so can we have it on 8th?
You,
Though it's a nomenclature as an appeal, basically it's a bail petition. 8, item 8.
no, what I'll do is,
Item
Mr.
13.
Mr. Kamar, what I'll do is that I am not passing any orders, will be
Fine.
adjourned. Thursday morning, make a mention, we'll get it listed.
Sure.
Because what is happening if in item, supposing your item is 10,
Fine.
I'm passing an
Fine.
order in item 10,
Got
and in 9, I am not passing any
Yeah,
order.
I got it.
Tomorrow you will question me that how an order could be passed in item.
Right.
So that is why
On
I
the
said
mention, I have taken his consent, we'll mention it on the 8th.
you take it
So
up on
take
that
it
day.
up. Okay.
Item number 8, your lordship, a report from the FSL is awaited. There also the same problem in item number 8. The FSL was directed to examine whether the semen found in the undergarment of the young girl matches with the appellant. So that report is awaited. So if your lordship takes it up on a fixed date, they have sent it, that is the notice that is received by the.
I understand, you make a mention on day after tomorrow, we'll just roll it over, make a mention, we'll have a fixed date given. I'm not fixing any date. Make a mention day after tomorrow. I'm not passing any orders in between. So all those will be rolled over. But thanks for reminding me of this book. Now I'll again read it. Modi's Medical Jurisprudence and Toxicology.
Monday, we are not minor, while in court number 1 minor, he said that I'll give you bail, but you have to show that you have got the book, what is jurisprudence. He said, I have it in my chamber. Ultimately, he didn't have it, so he went to the vendor, got it ordered, then got it and showed it to the court. Because that's a really good thing. Avjit Singh, no?
I recollected something after more of 20 years, so I was just reminiscing about this.
That book is really.
For a trial court, one must know it.
Absolutely.
Otherwise, it becomes very difficult. The chain of thought.
Probably this is
Not
the
be there.
latest, earlier which we had in Minor, that was a
Smaller one first.
Hmm?
Smaller one. Today I have.
No,
seen it
Modi's
bigger.
is that big only. Earlier Modi's also is that big.
No, not that. Because
Ah.
I have it, I could see, have a something.
Either it is Modi or it's a Ratan Lal.
Ratan
No, no,
Lal is
not
one of
Ratan
the-
Lal.
Modi.
Modi's is been, huh?
One of the best.
What madam said?
What we have is a bound volume.
Yes, bound volume, bound volume.
That is how it is more bigger.
Ah.
That's the same one.
আমার তো
There are many additions.
I have the
Change
30
in
days.
page
No, old
numbers
book.
and all.
When I read it 20 years back, it's a old book. This big. It's what do you call greenish, greenish bluish, greenish bluish light. I'm sorry, this is one of my default cases. Here. You'll have to refresh me because it's a long back.
My lord, actually the matter was fixed yesterday for hearing.
Yes.
And since it came up to be spoken to, I was instructed by my senior to perhaps seek your lordship's observation on why it was listed for to be spoken.
No, in fact, it's been a long back when we have heard it. Some refreshing of memory would be required because otherwise I'm forgetting the, what do you call, the sequence of the events.
If it's not inconvenient to your lordships, my senior has requested if the matter could be fixed or after 15th of February. He will appraise your lordship on the points since he would be submitting. Perhaps today we also short on time.
Uh,
The site is
okay,
open.
can you just have a talk with Mr. Nayak?
It was outside a while ago.
They've agreed to a date after 15th.
My lord, my instructions from my senior is that he would be available after 15th of February. I'm not
Okay,
sure about this.
just catch up with that.
I'll have a
Ah.
talk.
After the matter, we'll then post a date
My lord,
with consent of both sides.
I'm okay.
Mr. Nayak?
Yes.
This is one of my default cases where it has been kept pending for long. I'll need some refreshing hearing because it's been a long back and therefore
Lordship is fixing a date.
you agree to a date, both of you. He says,
15th of February, Lord.
agree to a date, we'll fix out that day.
Zero point, yeah. Tuesday, point. 20th, perhaps, yes, 28th, Lord.
Hmm?
28th of February,
28,
20.
20, okay. Mr. A. Barwa, counsel for the applicant, and Mr. P. Nayak and counsel for the respondent are present. So it appears that a refreshing that a further hearing is required in the matter. As the matter was heard long back, so as agreed to by both sides, list the matter on 20/2/2024.
Our written arguments are revised on record, my lord.
It's there, just because you see, when it is taking after a long time, if I miss out something, then it will be more bad.
Of course. ma'am. I'm obliged.
Because it's in what you call written mode and something which is which is being heard. It makes it a lot of difference.
Of course. Obliged.
But I'm extremely sorry this default has occurred in the matter.
Item 2.
That's
Wait, please. Last question, my lord, I have submitted regarding the suit land, how it has come to my hand. Nur Muhammad, the original Patadar, gifted his land to his five sons, and subsequently one of the sons, Ashraf, sold the suit land to Baliram Bora. Then Baliram Bora sold it to Kafetullah and Kafetullah to me. That was the facts I have narrated in the last occasion. So far, my lord, acquiring the title of Baliram Bora, purchased from Ashraf Ali. His name was recorded in the records of right. The documents which I am relying the suit has also been relied by the present appellant. And his, my lord, mutation was granted on the basis of purchase. It is not disputed either in the trial court or in a manner. The land which he has purchased from Ashraf Ali has been purchased by me. I have purchased the land from Kafetullah. Kafetullah purchased it from Balirampura. Balirampura purchased it from Ashraf Ali. Ashraf Ali was one of the brothers of Manik Ali, descendant from Nur Muhammad.
You purchased it from
I purchased
Baliram,
Kafetullah. Kafetullah.
Kaifat Ali.
Kafetullah.
He
Kafetullah purchased it from Baliram Bora on 26/5/1977.
26
26/5/1977.
5/1977.
Sorry, madam. Kafetullah purchased on 11/4/1970. 11/4/1970.
11/4/1977.
78.
78.
Kafetullah purchased it from Baliram Bora. Baliram Bora purchased it from Ashraf Ali on 26/5/1977.
Baliram purchased it from
Ashraf.
Ashrafullah
Ashraf.
on 26.
6/5/1977.
Yes.
Same plot of land which Balirambra purchased from Ashraf, and accordingly his name has been recorded in the records of right. Subsequently, he transferred it to Kafetullah and Kafetullah to me. And so far his name recorded has been recorded in the records of right. That has been noticed by the present appellants long before. Because subsequent to that sale, the present appellant's predecessor in interest Manikan sold, and other brothers, along with other brothers, sold one another part of the Sudda. That was also recorded in the records of right. Now the documents, that is Exhibit 1, is the same document which is also marked as Exhibit Go by the appellant.
That is Jamamadi.
Jama.
You had made it exhibit 1.
I made Exhibit 1, Exhibit 2, man.
Two.
Exhibit 2, man. I made Exhibit 2. Exhibit 1 is the sale name.
And appellants, they have marked it as exhibit Go, GA.
GA. Now, land under Suddak. Suddak was my lord 174. 174 consists of 1 bigha, 1 katha, 11 kasa. After my lord, bifurcated some portion of land to another for government. That is also recorded in the records of right. Presently remains my lord 1 katha, 1 bigha, 1 katha, 11. I purchase only 1 katha, 10 lasa, 14 lasa.
Suit land of 174 is 100, sorry, 1 bigha.
1 bigha, presently my lord 1 bigha, 1 katha, 11 lasa.
One lasha. This is before your purchase or after your purchase?
At the time of my purchase. It is not, as per my lord, page 11. Two katha, 4 lesa. 2 katha, 4 lesa have been totally from the original Suddak. Originally it was my lord 1 bigha, 3 katha. 15 lesa. 1 bigha, 3 katha, 15 lesa.
1 bigha,
3 katha, 15 lesa.
15.
15 lesa.
Then
Then page 11.
that is which entry?
Entry my lord first, third entry my lord. Page 11 my lord, of Exhibit 1.
Page 11.
Of Exhibit 1, first part.
I will also call. অসম গভর্নমেন্টৰ গেজেট নটিফিকেশনৰ 12/2/70
Just page 11 of the documents.
Page 52 is a legible one, my lord, if you look at it.
Page
52.
52.
Legible.
Page 52, yes.
1969 চনৰ 11 নম্বৰ ভূমি অধিগ্ৰহণৰ বৰ্তমান অসম গভৰ্নমেন্টৰ গেজেট নটিফিকেশনৰ 12/2/1970 তাৰিখত 70 তাৰিখত প্ৰকাশিত উপায়ুক্ত নম্বৰ JN নম্বৰ 13/8/70 তাৰিখৰ হুকুম মতে 137 দাগৰ 3 কথা 2 লেচা আৰু 174 দাগৰ 6 অংকৰ 2 কথা 4 লেচা মুঠ 1 বিঘা 6 লেচা মাটি 1.85 পইচা ৰাজহ কৰ সহ 1 2 3 4 5 6 নম্বৰ সামৰিক বিভাগৰ নামত চৰকাৰী কৰা হয় আৰু 174 দাগৰ অংশ 786 787 788 দাগ হয় two কথা 4 letters have been taken away from the should dag.
Just I'm not being able to follow. So ভূমি অধিগ্ৰহণ অধিগ্ৰহণৰ অসম গভৰ্ণমেণ্টৰ গেজেট নটিফিকেশ্যন নম্বৰ so and so ইমান দাগৰ মতে ইমান দাগৰ 3 কথা 2 লেচা আৰু ইমান দাগৰ 2 কথা 4 লেচা মুঠ 1 বিঘা মাটি চৰকাৰীকৰণ কৰা হ'ল yes
If 2 কথা 4 letters is added with the present minor land existing land it will be minor 1 bigha 3 কথা 15 letters.
I'm not being able to follow you. Why addition?
Present existing land is 1 bigha 1 katha 11 letters. Earlier it was 1 bigha 3 katha 15 letters. 1 bigha 3 katha 15 letters. And there is no dispute as regards to having more than 1 katha 14 letters of land under should dag land. There is no dispute. We are admitting that, and they are also not disputing in that regard. But I am submitting before also be said that so far the mutation of the first purchaser.
No, you see, the reason being page 48
Right.
is the Jamabandi. 174 has
1 bigha 1 katha
1 bigha
11
1 katha 11 lechas.
is the present one. After bifurcating some portion of land in the name for government. It remains minor. Even if minor so far that part is concerned minor. I am confined only to minor 1 katha 14 letters of land.
No, because you see, you are saying it contained 1 bigha 3 katha 15 lecha.
If I add
The page 52 which you are showing
Right.
does not say that after this land acquisition, the Pata land was corrected. So therefore, even if it is acquired, the land will remain under dag number 174.
Right. That's
So the
enough.
land would be 1 katha 1 bigha 1 katha 11 lechas. But you are saying that original land was 1 bigha 3 katha 15 lechas. That's why I'm saying I'm not following it.
So far I have considered the matter. I have seen that some more land has been mentioned. Some portion of the sale etc. matter. How it has come more land matter. I have gone through this document matter. Then I have seen that some portion of land has been matter from the original matter document 170. So after if we weigh that part matter, that presently it remains matter 1 bigha 1 kata 11. Presently matter remains 1 bigha 1 kata 11.
11 acres.
Right.
Because when it comes to 1 bigha 3 kata 15, therefore I'm saying I'm not being able to follow you.
It remains matter presently it remains matter 1
want to say
bigha 1
something?
kata 11.
They originally land was 1 bigha 3 kata 9 lacha. But I just pointed out to my lord that a portion of land that has been, my lord, the separate dark number has been created. So it came to be, my lord, 1 kata and 1 bigha 1 kata 11 lacha. Baliram Gora, my lord, I have in my, my lord, type copy of chart prepared. If you
Yes.
kindly see. Next page 2. 7. 1 bigha 1 kata 18 lacha. Lordship got it page. Just one row over. Page 2.
Yes.
1 kata 18 lacha, right? Order dated 12/4/2002, out of the total land measuring 1 bigha 3 kata 9 lacha. Lordship got it.
Yes. Second last.
Second last.
Yes.
Land measuring 1 kata 18 lacha was mutated in the name of Boliram Bora on the basis of purchase in place of subjurally. In this connection, a new bag being Itna measuring 1 kata 18 lacha was scraped out of the total measuring 1 bigha 3 lacha order dated, so a separate patta being patta number 278 was issued. Because of this, my lord, ultimately this land become 1 bigha 1 kata 11 lacha.
Okay.
It was originally 1 bigha 3 kata 9 lacha.
9 lacha.
While arguing with the matter, my lord, I pointed out to my lord because I found it there. We relied on this exhibit 2.
Yes, now it matches. Okay.
Basically, we relied on exhibit same thing that relied on exhibit 2. Basically, to show that the land, total land which comes in 174 now, as per the Jamabandi,
Is 1 bigha 1 kata 11 lachas.
more than that, as per the entry in the Jamab.
Hmm?
As per the entry in the Jamabandi, so there is 2 kata and something more land is there. Where from it comes? They say that we rely, they rely on exhibit 2, we rely also exhibit both the same document. But our reliance is basically, your lordship would like to go to the written statement as well as the evidence. So that we are relying that the more land is there. So how more land can be sold? Then the 1 bigha 1 kata 11 lacha.
There could be a possibility that we are, what you call, transfer of the same land is being considered twice and therefore there is an increase in land. 1 kata of land is sold twice. Maybe.
Those everything I have taken into consideration.
Hmm?
In the chart, we would have shown, as if your lordship kindly, from entire reading of the Jamamandi, I have find out, because then once sold, again sold, again sold, I have marked it in my chart. In my chart, page 1, your lordship will find bold letter.
Yes.
Bold letter. This portion was sold twice, twice. Then another, the next bold is also the same land actually. The earlier, these first 3 are the same 3 entries are here again.
Okay.
For my lord, subsequent sale after purchase by Baliram Bora. Here may be some my lord, discrepancy, here may be some, there may be some irregularities. That will not touch our my lord title, because how? Baliram Bora is the first person outsider who purchased 1 cut of 14 acres of land from the my lord, joint title holder Ashraf. Dasnur, Ashraf, Sonkor, Faizuddin and Malik. They got total my lord 10 bigha, 5 acres of land from Nur Mohammed. So 10 bigha, 5 acres of land under 4 darks, 4 or 5 does more than including the mother of dark. They have agreed the title. So one of the title holder, Ashraf, first sold Baliram Bora. And so Baliram Bora, we are connected with Baliram, not with others. Baliram Bora was the first outsider who purchased the land from one of those persons. So we purchased from Kafetullah purchased from Baliram. And so for one sale, second sale, madam, our land has been sold twice to several persons. It may be there, madam, may not be there. We do not know, but we are confined only to that part. 1 acres of land was sold by Ashraf Ali to Baliram. And so far that part is concerned, even madam, no pages are there in the registers. There is no say that or more we are purchased. Accordingly, madam, having named of Baliram Bora, the records of right, and having not disputed his title and position, and even not disputing his mutation, even no challenge has been made to the title and position or mutation of Baliram Bora by any person, either by Tasnur, Ashraf, Kunkor, Faizuddin or Malik, or any other else. No one has disputed his title and position. And his mutation was not never been challenged by any person. And in the present suit also, the present appellants never has stated that Baliram Bora did not purchase any land from Ashraf, or Ashraf did not have any right to sell any portion of land to Baliram. And the Baliram Bora purchased by the registered sale on 26/5/1977. Since it was purchased in the year 1977, and his name was recorded in the records of right on 26/5/77, তাৰিখৰ হুকুমতে এখন জাগৰ 1/14 মাটিত আশ্ৰফৰ লগত পৰিলাভূতে বলিৰাম বৰা নামজাৰিভুক্ত কৰা হয়।
You are reading which page?
আৰু পেজ 51 মাইলত। So my lord, Baliram Bora's title, position, mutation had not been challenged by any person, my lord. Accordingly, he got the right to sell his proportion of land to any person.
It is Upaprati Hamavarta. Additional,
Circle.
no,
Medicine. Medicine.
Sub-Deputy Collector. Upaprati Hamavarta. Sub-Deputy Collector.
Which we call as
SDC now circle office.
Hmm?
as
Now, as designated as circle office.
Then his name was recorded in the records of right. Subsequently, Baliram Bora sold it to Kapetula on 11/4/1978. Now, so for sale, transfer of the suit land by Kapetula to me was alleged. It was the defense of the matter, present appellants. In their written statement, in paragraph 16. Paragraph 16, madam, page 20.
Yeah,
Of their, this memo that, and memo that.
Mopil.
Paragraph,
Page
is 20.
20.
Paragraph 16, madam. Very,
Which page?
page number 20.
20. Yes.
I am citing this paragraph because the fact, in the earlier paragraphs, there is no such specific defense of the response defendants, present appellants, and how I cannot purchase what is my status, etc. Only evasive denial was there, madam. That is why specifically they have denied by taking a plea, how I cannot claim that property. Paragraph 16. Then the true position of the suit land is as under. The suit land, along with other land, bought by the Patta in suit originally belonged to late Nur Muhammad. After the death of Nur Muhammad, his 5 sons, that is Dr. Ashraf, Tulkor, Faizuddin, and Manik Ali, who is the father of the defendants, got entered and by way of gift, and their names were entered in the records of right. Since then, they had been possessing the entire land under the aforesaid Patta number 118 jointly in their own right and title. Next one. The suit land, along with other land towards the south, in one compact plot falls in the share of Manik Ali. Manikali had a Katsa house in the suit land where he ran a shop. This was the basic defense that suit land along with other land. It was my lord, he acquired the title over the suit land along with other lands from his father by the gift. And this particular suit land falls in his cell. In his under sentence, he stated the entire land under the Sikh suit patta have been jointly possessing by them, 5 brothers, and this particular suit land falls in his cell. This is his first defense against my title. Now, so far the sale made by Kafetullah to me, the defendants, that is the present appellant stated in paragraph 8, page 16, in the middle portion.
Yes.
7th line from bottom line, paragraph 16. This stated the entry of the name of the plaintiff in the Jamabandi Pata number so and so Buhai Gaon, Sorabai Muzad Jurhat, if at all made, has been made surreptitiously in as much as Kafetullah had no authority to sell the suit land. The plaintiff therefore has no right, title, and interest in the suit land. The right to sell, that was not with Kafetullah. That is why from Kafetullah we cannot say that we have acquired the title. Prior to this, my lord, so far the Kafetullah's right to sell is concerned, they have denied his title. The basic defense which they have taken in nutshell that Kafetullah had no right to sell the suit land. That has been explained in paragraph 16 that the suit land falls in their share. Other than this explanation, so far their defense is concerned, their WS was silent. Now, in addition to that defense, that suit land falls in their share, they have taken one another ground reason, showing that the sale deed, which was on the strength of which I claim right title and interest, was a fraudulent one in their evidence in sale. Apparently, it is the duty of the minor defendants to show that the suit land falls in their share. They ought to have laid evidence in that regard that the suit land basically and the suit land basically falls in their share. Otherwise, my lord, his earlier statement will contradict because he stated the entire 10 plus 5 lessons of land have been gifted out by their father to 5 sons. They are jointly possessing the same land. Now, since his claim was such that the entire land under the suit patta was jointly possessed by the 5 brothers, then subsequent statement that the suit land falls in his share, it is the duty of the defendants to show that it falls in his share because it is his personal knowledge. Section 106 will come to my lord. So far, his statement is concerned, madam.
Please come again, Mr. Sharma, what you're trying to say?
Hello.
You are saying that
I'm saying that the basic defense taken by the present appellant in the suit, that the suit land falls in theirs, in his cell, that is the appellant's cell. In para 16 of the written statement. And it was the explanation, the defense, to their defense that the cafeteria had no right to sell.
no, in this para 16, this is the should land belong along with other land towards the or a compact was in the share of Manikali.
Manikali was the predecessor in the interest of the present appellant.
Yes.
So, but the suit land along with other land towards the south, man. Bifurcated a particular portion, not towards any
No,
other
they are first taking in para 16 at
Right.
page 20. They are taking a plea that
joint position.
the entire land was gifted to them, five
Gi-
brothers.
Gifted to them, 5 brothers. And accordingly, the second statement was that the entire land was under their joint possession.
Yes.
It is the statement of the
Yes.
minor defendants. And subsequently, the defendant stated the suit land along with other land towards the south in one.
Just don't let me read online because I'm not being able to catch it. Yes.
First statement was a joint position. Being might have included that, but subsequently, the defendant stated there might have difference basically that the student says was in their share. So cafeteria had no right. Defendants have denied the right of cafeteria to transfer the land because of the fact that the student falls in their share.
Yes.
The entire WS, my lord. It is not disputed and challenged that Baliram Bora purchased the land from Ashraf Ali, which is the Sud land. And it is also not denied by them that Kafetullah purchased the Sud land from Baliram. They simply stated in paragraph 8 of the written statement.
Yes. So you're saying that out of the 5 sons,
My lord.
your vendor purchases from Ashraf Ali.
Original, my lord, vendor was Ashraf Ali.
And thereafter he transferred the land to you.
No, Ashraf Ali sold it to Baliram.
But that's what I'm saying.
My lord. From him, I have this.
Baliram purchased from the one of the 5 sons. Yes.
So, my lord, so for the transfer, which was made in respect to Baliram Bora, Kafetullah was not sentenced and never been sentenced.
Yes.
The defendants, the present appellants. That is their contention that you have no right to title and interest because Kafetullah had no right to sell the transfer land because it falls in our share and we have right to the interest on the strength of inheritance from our father. So since they have not challenged and denied the title of Kafetullah and even not challenged the mutation of Baliram Bora or the sale made by Ashraf to Baliram. Now they have actually no right to. They become stranger to the in respect of the land purchased by Baliram Bora. But since they have been possessing my land initially as a permissive occupier, subsequently they are hostile to my title. So they are not claiming any adverse position against me. But it was the duty and it was the burden of the defendants to show their right of possession over the Sud land. Their right of possession over the Sud land basically, as per their written statement, that the Sud land falls in their share and they have right to an interest derived from their father, Manik Ali, and their father, Manik Ali, derived from his father, Nur Muhammad, as gift. So they have to show that the Sud land falls particular in their share. Otherwise, they cannot say that they have right to occupy the Sud land as title holder. They had to leave evidence to that effect that right of possession over the land basically on the state of title as it falls in their share derived from their father. But their evidence silent to that effect. No witness, no evidence have been laid by them which reflects particularly the Sud land falls in their share. While filing the written statement, the appellants have also not challenged my cell deed or the capitular cell deed or my claim and their claim by your counterclaim. They have not made any counterclaim declaring, seeking any declaration as to their right to land interest in position, confirmation of position or right of position. Nothing else. Counterclaim was not filed by them. The only difference basically to their pleadings that it falls in their sale. Now, the second explanation given by the by the defendants appellant to their evidence that the sale deed on the strength of which I am claiming my right to an interest is a fraudulent one.
That last time you said,
Since it is a fraudulent one, it is the onus on the part of the minor appellants to prove how it becomes fraudulent. When fraud has been committed. It is also minor beyond pleadings, minor. In their written statement, they have not stated that the sale title deed of capital or mine was a fraudulent one. That was the pleaded minor. But in their evidence, they have stated as such. Though it was pleadings, however, they ought to have leave any sorts of evidence which substantiates that fraud was committed in execution of the said sale, either of the capital sale deed or of my sale deed.
yes.
I'm pointing out the second paragraph of the 1C minus page 31.
H,
31 of evidence paper book man. 31 to 39 of the statement of DW1 Faizuddin Ahmed.
of that compilation.
Fine.
Okay. Yes.
I read the second paragraph. First paragraph is আরজি তফসিল কর মাটি বাড়ির মাটি নহয় উক্ত মাটিত বাড়ির কোনো সত্ত্ব দখল নাই বাড়িয়ে দাখিল করা প্রদর্শক এক ঘর অর্থাৎ বিক্রি দলিল ঘর জাল ভুয়া আৰু বেআইন কাফাইতুল্লাহ 29/1/90 ইংৰাজী তাৰিখত গোচৰীয়া গোচৰৰ মাটি বিক্ৰী কৰাৰ কোনো সত্ত্ব অধিকাৰ নাই এই কথা গোচৰীয়াই দাখিল কৰা জমাবন্দী অৰ্থাৎ প্ৰদৰ্শক স্পষ্ট হৈ আছে প্ৰকৃততে গোচৰীয়াই গোচৰ লগা মাটি চিনিয়ে নাপায় তেওঁ গোচৰৰ মাটি কোনোদিনেই দখল কৰিবলৈ যোৱা নাই কাফাতুল্লাহ কোনোদিনেই গোচৰীয়াক গোচৰৰ মাটি দখল চমজাই দিবলৈ যোৱা নাছিল গোচৰীয়া পট্টাৰ মাটিৰ বটৱাৰা হোৱা নাই পূৰ্বতে গোচৰীয়া পট্টাৰ তাবত মাটি নুৰ মহম্মদৰ আছিল নুৰ মহম্মদৰ মৃত্যুৰ পাছত তাবত দাগত অন্য ককাই ভাইৰ লগত বিবাদীৰ পিতৃ মানিক আলীৰ নামজাৰি হয় গোচৰীয় মাটি মানিক আলীৰ অংশৰ ভিতৰত পৰে contradictory statement. Once stated that it was not partitioned. Subsequently, he stated false in his sale. And so far, the allegation of that it was fraud জাল ওয়ার বেআইন, it reflects as stated কাফায়েতুল্লাহ 29/1/90 ইংরেজি তারিখ গোচৰৰ মাটি বিক্ৰী কৰা কোনো স্বত্ব অধিকাৰ নাই, এই কথা গোচৰীয়াই দাখিল কৰা জমাবন্দী অৰ্থাৎ তদন্ত শক্তিত স্পষ্ট হৈ আছে। This is the reason assigned how it becomes জাল ভুয়া and বেআইন।
Yes.
So from the pleadings, as well as from the evidence in sheet of the appellants, it transfers that since the suit land falls in their share, Kafatullah did not acquire any right to sell the suit land, number one. Number two, the sale deed, basing on which I am claiming title, is a fraudulent one, fake one. That is why plaintiff cannot seek any right to an interest over the suit land. Now, yes, as a plaintiff, I have some duties and burdens to prove my own case. I have submitted and exhibited my sale deed, title deed, basing on which I am claiming. But so far there are differences because it is a fraudulent one and manufactured one. In relation to that defense matter, they have not put any question to me.
This page 31 is, this is the evidence of, whose evidence? Page 31,
Page 31 is the DW1.
DW1.
DW.
Yes.
So far, DW was a long one, I thought. So far, the basic research, so far, we have put questions as regards to his first allegation that was in his cell. When page 36,
Dr. Rice. This,
if
you were referring to the Devtar Mithir episode, that part.
more data, last 3 lines from page 35.
35. মোৰ দেউতাৰ কিমান অংশ মাটি?
মাটি ককাৰ মৃত্যুৰ পাছত পাইছিল নাজানো।
Yes.
কেইদাগত মাটি আছিল কব নোৱাৰে, কিন্তু 274 নম্বৰ দাগত আমি আছো। জমাবন্দীত কাফায়েতুল্লাহ আৰু লুৎফুৰ ৰহমানৰ নাম পাইছিলো।
Oh.
Dag is 174.
Okay. You said you have some difficulties.
My lord. Yes.
So when should we fix it?
Did it go to first week of March? Or it will be-
No issue, because my bench would be, no, it would be, consistency is not there. Therefore,
Sixth, Sato said my order is there. So on 6 and 7, I will not be there.
6th and 7th February. No, it's going to March. He has some personal difficulties.
I was also taking medicine while entering the. I was also taking medicine while entering the.
Maybe it's different here, but my other difficulties are there. So if I come to here, I can't devote their time, so this is the difficult. Anyway. No. Let it be on 7th of March. So you would like to hearing date?
7th of March.
7th.
What is there on 8th? Why there is
It
a,
is holiday.
why,
Shivaratri.
Shivratri, okay, then 7th. Mr. K. Agarwal, Senior Counsel, assisted by Ms.
New.
P.
New.
No, I'm sorry. Ms. P. Neo, Counsel for the applicant is present. His submissions of Mr. M. K. Sharma and Counsel for respondent remains inconclusive due to paucity of time. Next paragraph. The learned senior counsel for the applicant has submitted that he has some personal difficulties in the in the month of February 2024, and therefore prays that this matter be fixed on 7/3/2023. Considering the submission, the prayer is allowed. List on 7/3/2023 as part of matter. 2024, sorry, 24.